Well, friends, good evening. Others are joining, but we'll be starting the class immediately. Uh,
Okay, sir.
so this is a new topic in the third unit. This is about the winding up circumstances. You must be knowing what is the meaning of winding up. When the company is getting close, we call that process as the winding up process. I'm going to share with you the screen. Just wait a minute. Uh, Screen will be shared with you. Just tell me if it is visible. Are you able to see the screen? Are you able to see the screen? Am I audible?
Yes, sir.
Okay. Are
Yes,
you
sir.
able?
Yes, sir. Audible, sir. Yeah, visible, sir.
Screen is visible. Okay. So we are going to
Yes, sir.
today. Our topic is about the winding up circumstances. So when you talk about the winding up, we are thinking of the process of closure of the company, right? So in the syllabus, if you see your third unit, this
Sir.
particular portion is there. Circumstances of winding up. We are going to learn all of the aspects we have covered.
Yes, sir.
This class will be focusing only in this part, and next class will be covering this
Okay,
legal
sir.
aspects of audits and accounts and audits. Okay.
Accounts and audit. Yes, sir.
That will be there in the next class, but today only circumstances of winding up. We'll start and finish that process. Okay, first we need
Okay,
to
sir. Please.
understand what is the definition of winding up. We understand it loosely. We are talking about the closure of the company. So if you want to understand the definition, it has been defined under section 294A. Right. So section 294A of the Companies Act defines winding up like this. Winding up means winding up under this act. So under this act means Companies Act 2030 or liquidation under IBC. This is popularly called as IBC, but expansion is Insolvency and Bankruptcy Code 2016. Okay, this is a code through which a company can be liquidated. That liquidation process also will be referred to as winding up. So winding up means two things: winding up under Companies Act 2013 or liquidation under IBC 2016. Okay, is it clear? This picture shows winding up includes winding up under Companies Act and also liquidation under IBC 2016. Both the things are is to be understood as winding up. Okay.
Okay, sir.
Okay, fine. Now having understood that this is winding up, we'll be seeing the circumstances in which company may be wound up. So first of all, a company may be wound up on a petition. A petition may be filed under section 272. A petition can be filed to the tribunal. Tribunal means National Company Law Tribunal. That is a quasi-judicial body. You need to understand. You can also visit to the sites of NCLT. This is called as the tribunal when you talk about in the context of Companies Act. Tribunal means National Company Law Tribunal. Okay, you can visit to their website and understand how they function. Quasi-judicial body. This is created by Ministry of Corporate Affairs. It has got several benches. So fortunately, one bench has been opened at Cuttack. Earlier, we are not having NCLT bench in Odisha. Right now, there is a NCLT bench in Cuttack. Okay, so application can be made or petition can be filed to NCLT bench. Okay, just a minute. Yeah. So through petition, winding up is possible. Right. In these circumstances, if the company has by special resolution resolved that the company should be wound off by the tribunal. If company passes a special resolution, you must be knowing what is a special resolution. Can anyone, if you explain what is the meaning of special resolution?
Sorry, apart from the regular operations.
Yeah, but what we're talking about, that is about special business.
Sir,
Okay.
special business,
So
yeah.
in a
Apart from
meeting,
regular business.
some business can be your ordinary business, some business can be a special business. Okay, but we are talking about the special resolution. In business, in a kind of meeting, decisions can be taken through resolution. So some of the resolutions are
Yes,
called
sir.
as
Yes, sir.
ordinary resolution, and some of the resolutions are special resolutions. Can you explain
Sir,
me what is a special resolution?
special resolution.
Well, let me explain you. This is a kind of resolution
Yeah,
where the uh, business is such that votes cast in favor of the resolution must be at least 3 times in excess of the vote cast against the resolution, if any. Right? That means this is the kind
okay.
of resolution for which at least 75% majority is required. 3/4
75%. Yeah.
majority is required. And in addition to that, notice must have been given that this kind of that a special resolution is going to be passed. To that effect, a notice must have been given about the special resolution, and in addition to that, the resolution must have been passed by a 3/4 majority. Right? If the company has passed a special resolution that it is going to undo, company himself is filing a petition to the tribunal with a special resolution that we want to close the company. Then it is possible. That is one circumstance. Okay. Now the second circumstances is that you see the company has acted against the interest of sovereignty and integrity of the India. So against sovereignty and integrity, the company has acted, or against the security of the state, or against the friendly relations with foreign states, or against public order, or against decency, or against morality. If the company has acted against any of these things, then company can be wound off by a petition to tribunal. Okay, so these are certain circumstances, right? In these circumstances, company can be wound off. Okay, now third circumstances we have to see. Third circumstances is that if on an application made by registrar, so company registrars are there in different states. They are called as ROC offices, the register of the offices. On an application made by a registrar, that means the ROC, that the registrar can make an application, or any other person authorized by central government. Central government may authorize somebody to make an application, right? Any other person authorized by central government by notification under this act. Okay, so because of this application made by ROC or application made by an authorized person, if the tribunal is of the opinion that the affairs of the company has been conducted in a fraudulent manner, so tribunal feels that affairs are conducted in a fraudulent manner, okay, that means there is some kind of fraud involved, or the company has formed for a fraudulent purpose, unlawful purpose, so for a wrongful purpose, company has been formed, if that is the kind of situation, or the persons concerned in the formation of the management and affairs of the company is guilty of fraud. Already the people who are behind the company, who are looking after the management of the company, are guilty of fraud, or misfeasance, or misconduct. Misfeasance means some kind of wrongful doing or misuse of authority, that can be called as the misfeasance. If this kind of activities are involved, either there is a fraud, misfeasance, or misconduct in connection with the company, then application can be made by the registrar, or application made by a person who is authorized by the central government to the tribunal, and the tribunal may pass an order for winding up of the company. Okay. If the company has made a default in filing with the registrar the financial statements and annual return, this is another circumstance. In this circumstance also, company can be wound up. When you're talking about the winding up, that means we are planning to kill the company. And company normally lasts forever, is it not? It has got perpetual existence. But if somebody wants to kill the company, that has to be killed through a lawful manner. And these are the circumstances through which you can close the company, or we can kill the company, you can say. If the company has made a default in filing with the registrar the financial statements or annual returns. So if you form a company, or every company is required to file with the registered company the financial statement, the balance sheet, profit and loss statement, etc., needs to be filed on annual basis by a particular date. If the company has made a default or has not filed annual returns, companies are also required to file some kind of returns annually in a particular form. That return is filed, that is called as MGT7. MGT7 is filed annually. That filing is required mandatorily. If the company has made any default in filing both the things or any of these things, financial statements or annual return, consecutively for a period of 5 years, then also a company can be closed. And lastly, one more circumstance is that if the tribunal itself is of the opinion that it is just and equitable to close the company. If the tribunal feels that it is justified and it's equitable that the company should be closed, the company should be wound up, then also tribunal may pass an order to wound up the company. If we'll summarize all these things, you can find the 5 situations in which company can be wound up, or 5 circumstances in which company can be wound up. First is that you can read it by, can anyone of you read it by?
Sir. So by special resolution, sir.
By special resolution, that means here company itself decides to close the company. Then second is,
Yes, sir. Company has acted against the national interest.
National interest, against the sovereignty or integrity of the company, against security of the company, against a friendly relationship with the country, if with the friendly countries. If the company has acted, then company can be moved off. Then third thing is that
an application by the registrar or any other person otherwise by the central government.
ROC or an authorized person can make an application for winding up of the company. And the fourth situation is
defaulted filing financial statements,
yeah,
annual return,
or
immediately preceding 5 consecutive financial years.
Then also company can be closed. Then fifth,
on just and equitable ground.
If it is justified and equitable, and then the tribunal feels, NCLT feels that it's just and equitable, that company may be wound off, that company can be wound off. Right? So voluntarily, let us say,
shareholders.
Voluntary if you want to
for
close the
company. Sir, yes. For safeguarding stakeholders.
Yeah.
For safeguard the stakeholders' interest.
Yes.
Just equitable means thereafter it may be loss to stakeholders. Otherwise.
Yeah, maybe.
So in that situation,
one of the reason. Loss we cannot say because you see, loss may be there, but still company can be continued. But it is felt that it is justified. It is high time to close the company, so they may decide to close the company. Okay.
Based on maybe previous record and
there may be any reason. Tribunal before deciding must be recording the reasons for which it feels that it is just and equitable to close the company. Right. Now,
excuse me, sir. This is third point on application by the register.
Yeah.
On application by the register or any other person authorized by the central government.
Central government. Yes. This is, you see, the registrar of the company.
Yeah.
Right. Every state has got a register. Registrar may feel that something is going wrong with the company, or it may feel that company should be closed. The registrar himself will make an application to NCLT that the petition can be filed by to NCLT that company may be closed. That is one. Or any authorized person by central government. The central government may authorize somebody that on behalf of government you may file a petition for closure of the company. Then that person can also make a petition for closure of the company. That is the third point. On application by the registrar or any other person authorized by central government, these people can file a petition to the NCLT. Okay. Okay. Now we'll quickly see the petition for winding off section 172. Right. Now who can raise this kind of petition? Petition to the tribunal for winding up the company shall be presented by company himself or any contributory. Contributory means people who are who are expected to contribute in the event of winding up of the company. So normally they are the shareholders who have not paid their unpaid value of the shares. They might have to contribute. So these contributors can file winding up petition. They can present winding up petition. All or any of the persons specified in clause A and B, both or as a group or individually they can file. The registrar can file a winding up petition. Right, a person authorized by central government can file a winding up petition. Right. in case of falling in clause B of 271 by central government or state government. That is, central government and state government can also directly file only for clause B. What is clause B? You know, clause B means if the company has acted against the interest of the country, against the national interest. If that is the kind of situation, then central government or state government can directly present a winding up petition. Right? So these are the people who can file the winding up petition. Who are the contributors? Just now I explained you. Means a person who is liable to contribute towards the asset of the company in the event of being wound up. Right. So in case, now we'll see how in which situation contributory can file the petition. Contributory is entitled to present a petition of the winding up of the company. Right. But who can be that contributor? Shares, irrespective of which is contributory, or some of them were either originally allotted to him or have been held by him and registered in his name for at least 6 months. That means the person must be holding shares for at least 6 months during 18 months immediately before commencement of the winding up. So before commencement of the winding up process, right, within that 18 months immediately before the commencement of the winding up process, the contributory must be holding the shares for at least how much period? At least for 6 months. Right, he must be holding shares at least for 6 months. Shares must have been either originally allotted to him or might have devolved on him through death of the former holder. Let us say he might have acquired the shares through inheritance also because of the death of the former owner. In that case also, he will be still considered as a contributory and he can file a winding up petition. Okay. Now, petition by registrar. Registrar, you know, we can file a winding up petition. We can present a winding up petition under section 271, except for the grounds specified in clause A and E. What is clause A? If you recall, clause A means company himself will decide for winding up petition. Company himself will apply through a special resolution. So therefore, registrar cannot file because company itself will be deciding. That's a clause A. And what is clause E? Clause E is the last clause. That is when the tribunal finds it just and equitable to order for winding up of a company. So except in these two situations, a registrar can file winding up petition. Registrar can present a winding up petition except clause A or clause E. But here you have to remember one thing. If the registrar is willing to present a winding up petition, he needs a previous sanction from the central government. He needs to obtain the previous sanction for the presentation, and the central government shall not accord the sanction unless the company has been given reasonable opportunity for making representations. Okay, so central government sanction is required if the registrar wants to file a winding up petition, but central government will not give this sanction unless an opportunity is given to the company to make representation. The companies, an opportunity must be given to the company that this is the kind of situation we are going to apply for a winding up, so you can give your representation. Only after that, central government will permit the registrar to file winding up petition. Right. Now, a petition presented by the company. Suppose company wants to present the petition for winding up before the tribunal. It shall be admitted only if it is accompanied by a statement of affairs, right, in a particular form, in such form and such manner as may be prescribed. So if the company itself decides that winding up petition needs to be presented, then he has to, along with the petition, he has to present a statement of affairs. Statement of affairs means broadly you can say it is a kind of balance sheet kind of thing, where all the inflows of sources and application of the bonds will be there. Right, it will show what is the company's financial situation. On seeing that only, winding up decision can be taken up. So the statement of affairs needs to be presented by the company, and the copy of this winding up petition must be filed with the registrar, and registrar can submit his views to the tribunal within 60 days. So when the company files a petition, then a copy needs to be filed to the registrar, and the registrar can submit his views within 60 days to the tribunal. That is one more requirement. Right. And these are the powers of the tribunal. What tribunals can do under section 272, it can pass any of the following orders. The powers of the tribunal is explained under section 273. Right. It can pass these following orders. First of all, it's been dismissed. In a petition is made, petition can be dismissed with or without cost. That means it may order that the parties who are presenting this petition may bear the cost, or it may award cost, that they may be given, the cost may be reimbursed by the company. Okay, they dismiss it with or without cost. Make an interim order for the timing, an interim order can be made. Appoint a provisional liquidator whose job is to liquidate the company, who initiate the process of liquidation of the company, initiate the process of closure of the company. Okay, provisional liquidator can be appointed till making of winding up order. Right, when a winding up order will be made, then official liquidator will be appointed, but till that time a provisional liquidator can be appointed. Make an order for winding up of the company with or without cost. So this order can be passed, the company may be wound off with cost or without cost. That means cost may be awarded to the petitioners, or cost, it may be without cost also. Or it may pass any order as it thinks fit. So it is up to the tribunal, up to NCLT, it may decide what kind of order can be passed. So these are the powers of the tribunal. We can summarize. It may dismiss the order with or without cost, make any interim order, appoint provisional liquidator till the final order of winding up, make an order of winding up the company with or without cost, or any other order as it may think fit. So these are the powers of the tribunal in relation to winding up, and they may do any of this. Okay, now let us see the time limit for passing an order. An order under this section shall be made within 90 days from the date of presentation of the petition. Once the petition is made, order has to be passed within 90 days. Okay, right. And before appointing a provisional liquidator, notice needs to be served to the company, and company must be given an opportunity to present his representation, to make his representation. Right. So under normal circumstances, companies will be given a reasonable opportunity to make its presentation, if any, unless for special resolution to be recorded in writing, the tribunal thinks fit to dispense with such notice. But if there is a situation is special, and for special resolution, which needs special reasons, which needs to be recorded in writing, the tribunal must note that for these reasons, this particular opportunity is not given to the company. That means this particular opportunity of giving notice and calling for representation can be dispensed with. But in case tribunal is deciding something like that, it has to record the reasons, and reasons should be recorded in writing. Tribunal shall not refuse to make winding up order for certain reasons. Okay, for example, reasons is that shall not refuse the winding up order on the ground that assets of the company has been mortgaged for an amount equal to or in excess of the assets, or the company has no assets. Let us say company has some assets. Let us say company has assets worth 5 crore, but they are mortgaged for 5 crore, or a mortgage for a loan of 6 crore. That means if his assets are disposed of, whatever money will be coming, ideally it should go to the person who has lended money. Right? Who has lent money, he should get this money. So therefore, one may think that okay, if that is the say, then nobody is going to get some extra money because of this winding up process. The tribunal may refuse to make a winding order on this ground. But answer is, in this kind of situation, tribunal shall not refuse to make an winding up order, even if the assets of the company are mortgaged, and even if it is mortgaged for an amount either equal or in excess of those assets, or the company has no assets. In this kind of situation also, tribunal is not supposed to refuse to make an winding up order. Right. Then another thing is that another issue, tribunal can make an order for, if the tribunal finds that there is any other remedy, there is some other solution except winding up, then tribunal may order that thing also. Right? And this section says where the petition is presented on the ground that is just and equitable, that the company should be wound up, the tribunal may refuse to make an order of winding up if it is of the opinion that some or other remedy is available to the petitioner and they are acting unreasonably in seeking to have the company wound off. If tribunal feels or the tribunal is of the opinion is that other remedy is available, but these petitioners are acting unreasonably, they are taking some excess action and they are filing a petition for winding up of the company. And in these circumstances, winding up is not warranted upon. Winding up is not required, but these petitioners are filing and winding up petition. If this is the kind of situation, then tribunal may refuse to pass on winding up order. Okay, so this concept we need to understand. Yeah, and just before some time also we are discussing, tribunal may require the company to file a statement of affairs before passing the winding up order. Right, it may direct the company to file objections if the company has some objections to the winding up process, objection to the petitioner's presentation, then they may file it. They can file a statement of affairs within 30 days from the order. In such form, order means when the order is made by the tribunal to present the statement of affairs. Within 30 days, statement of affairs needs to be presented along with the objections if any. Okay, so tribunal shall make an order and direct the company to file the objection with along with statement of its affairs within 30 days of the order. Tribunal can make an order to make a presentation of objections and statement of affairs, and within 30 days the company need to present that. It's also possible to obtain a time extension, but tribunal can give an extension of further 30 days, but not more than that. The tribunal may allow further period of 30 days in a situation of contingency or special circumstances. Only those kind of circumstances, another 30 days can be allowed. The tribunal may direct the petitioner to deposit such security for costs. Tribunal may give direction that certain money needs to be deposited to meet the cost of this winding up process. So that is also possible. Tribunal can give direction. Some reasonable amount can be deposited. The directors or officers of the company, in respect of which order of winding up is to be passed by the tribunal, shall, within a period of 30 days of such order, submit at the cost of the company the books of account of the company, completed and audited up to the date of the order. When winding up process is going on, the tribunal may pass an order that the company shall, within 30 days of such order, shall submit the books of accounts of the company. The books of accounts of the company should be submitted to the tribunal, and some books of account means books of account completed till the order, till the date of the order, completed as well as the audited. Completed and audited books of accounts need to be submitted to the tribunal. Right. So this is broadly the circumstances, how these circumstances has to be dealt with in a winding up process when winding up happens through NCLT, National Company Law Tribunal. Now, in the context of winding up, we need to understand two more aspects which are important. One is overriding preferential payments. There are certain payments when the company is wound up. There are certain payments which we call as preferential payments. There is a list of such payments. In summary form, I will be showing you what are these payments. So preference should be given for these kind of payments, right? But there are two more other kinds of payments are there which will override the preferential payments. That means first these two payments has to be made, then only preferential payments has to be taken care of. But the first payment is workman's due. If workman's dues are there, it has to be paid fast, right? Second payment which will override the preferential payment is a portion of secured creditors liability. Secured creditors liability. If the company is liable to pay something to the secured creditor, right? That liability will stand pari passu with the workman's dues. We'll understand how to compute that. What is the security creditors, secured creditors due, which will be given priority or overriding preferential payments. Let us take an example to understand that. First, we have understood what is the first item, which will be overriding the preferential payments. I think you can see it. What's the first item? That is workman's due. Workman's due has to be settled first. Next is a portion of the secured creditor. To understand that thing, let me tell you this example. Suppose the value of the security of the secured creditors is 1 lakh. That means a particular debt is secured. Company has taken a loan and it is a secured loan or it's secured debt. And the value of the asset which is secured is only 1 lakh. And the total amount of workman's due is 1 lakh. And the amount of debt due to the company to its secured creditors is 3 lakh. So 3 lakh rupees is due to a secured creditor, but the assets which are secured, that is worth only 1 lakh. That means there is under coverage of security, or you can say loan is under secured. Right. Now, if you consider this thing, now this liability is 3 lakh to the secured creditors and workman's compensation due is 1 lakh rupees. Total 4 lakh rupees is due. Right. 4 lakh rupees is due and workman's compensation portion of the security, therefore, is 1/4. Workman's liability, workman's due is 1 lakh and the total liabilities, you can say 4 lakh. So, workman's due is 1/4. Therefore, 1/4 of the value of the security, 1/4 of the value of security, what is the security of the secured creditors is 1 lakh. 1 lakh's 1/4. That means only 25,000 rupees will be overriding preferential payments. That means this much of money, only 25,000 rupees has to be paid to the preference shareholder, not preference shareholder, shall be paid to the secured creditors. Right. So this is how calculation has to be made. First, workman's compensation has to be paid, then a particular portion of the secured creditors has to be paid. The way I calculated, in the same way that computation has to be made. Now, lastly, we'll be covering this aspect. What are the preferential payments in the event of winding off? If the company is getting wound off, then priority should be given to this kind of payments. First of all, government taxes has to be paid first. Second is salaries and wages has to be paid. Then holiday remuneration of the employees has to be paid. Contribution under ESI Act has to be paid. Compensation in respect of death or disablement has to be settled. Then pension fund and gratuity fund amounts has to be paid. Then expenses of investigation has also to be paid. These payments are called as the preferential payments. So in the winding up process, when the company is getting close, so first these liabilities has to be settled. Okay, this liability has to be settled. Okay, with this winding of aspects we have covered, we have completed it coverly, completed it totally. So in case you have any query, you may raise that query. We'll address it. Otherwise, we'll close our today's class. Next class will catch up with accounting and auditing aspects. Okay. Do you have any query, or we'll be winding up our class? We can wind up.
Yes, sir.
You can unmute and reply. Any query you have?
No, sir.
Okay. So we can close our class. We can again catch up with the other subjects, right? Audit and accounts, that is.
Okay, sir.
Okay then. Thank you.
Thank you, sir. Thank you, sir.
Thank you,
Good night,
sir.
sir.